My name is Alex Raskovich. I'm Director of Research for the Global Antitrust Institute here at George Mason. I'm delighted to be moderating this panel on intellectual property and antitrust with a distinguished panel of experts on that topic. We have Alden Abbott, who is Senior Research Fellow at the Mercatus Center here at George Mason. Dr. J. Ezrielev, who's the founder and managing principal of the economic consulting firm Elevecon, and formerly, I should have said Alden was general counsel for the Federal Trade Commission for a number of years. Jay is founder and managing principal of Elevecon, and formerly was economics counselor to the chair of the FTC, Joe Simons. We have Aurelien Portuese, who's the director of the Schumpeter project of the Information Technology and Innovation Foundation, and he's also an adjunct professor of George Mason University at the law school here. And then last but not least, we've got Professor Christopher Yu, who's the John H. Chestnut Professor of Law, Communication, and Computer and Information Science at the University of Pennsylvania, and also the founding director of the Center for Technology, Innovation, and Competition at Penn. Everybody knows which order you're going in. Alden, why don't you begin?
Thank you so much, Alex, and my fellow panelists. I want to especially thank the Center for Intellectual Property and Innovation Policy at the Scalia Law School, the sponsors for a great event. I know my colleagues are going to be talking about some legislative proposals and existing legislation in Europe, Digital Markets Act. I'm going to talk a little bit more about constraints that have and changes in the structure of the law that have weakened intellectual property rights. And those changes should be considered and merit being considered in light of the rest of the discussion. In particular, the major changes are that over the last decade, the U.S. Supreme Court has taken a number of decisions that's created great uncertainty about what is patentable, which is rather amazing. But there is also a number of other developments on the legislative front and in the executive branch and independent agencies that merit being noted. So let's look quickly. The United States, I think after the passage of the Patent Act back in 1950, was an extremely modern act, very, very broad. Section 101 of the Patent Act dealt with patentability, and the aim really was to make almost anything under the sun patentable. Operative language said, quote, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent, therefore, subject to other conditions and requirements of the title. And those conditions dealt with, novelty, prior art, things of that sort. But the idea is you shouldn't have had to consider such things. First, you wanted to look, is something patentable? Almost everything was. And indeed, in 1980, the Supreme Court in the Chakrabarty case said that even an engineered bacterium could be patentable. It was a 5-4 decision. But there was a very, very, very broad scope for patentability, which is very helpful, I think, for inventors, particularly when antitrust law, starting in the 1980s, began to recognize the importance of property rights. But the Supreme Court did engraft exceptions to broad patentability, not written in the statute, laws of nature, natural phenomena, abstract ideas. But starting about a decade ago, they created all sorts of new exceptions. There's several. We don't have time to discuss the specific cases. I commend you to articles in Truth on the Market, an excellent publication. But basically, in such areas as medical diagnostics software, some computer-aided uses, and now even more recently, some traditionally patentable mechanical things that are somehow tied and not viewed by some judge or as not independent from a law of nature, suddenly, which everyone would have thought was patentable or no longer patentable. That creates a disincentive to invest in patents. And of course, the key issue, and I think it's already been touched upon, is that investments in and patents really create competition in product markets, because new products and innovations through the patent system, which are distributed throughout the system through innovation contracts, through licensing. And Professor Dan Spolver has a good book on that. But those innovations allow the commercialization on several levels and the dispersion of technology. But if you're going to get on the margins severely reduced incentives to invest in these new areas because of uncertainty as to whether patents will be upheld, it's a big problem. At the same time, as was alluded to earlier by Professor Barnett, in 2006, the Supreme Court suddenly dropped the almost automatic rule, the property rule, that somebody who could prove it, his or her patent had been infringed, could receive an injunction. Now that's no longer the case. You have a balancing case test, and particularly, as he pointed out, in the area of standard essential patents, which are so important because standards, as was alluded to, are so important for developing technologies, sort of a platform for technologies. You'll have disinvestment in that area. And so that's a big problem because it's almost impossible in the U.S. to get injunctions. And indeed, as was alluded to, also, the executive branch now, Justice Department and the FTC, although there's been little litigation from them recently, they have certainly, through a variety of speeches and pronouncements, taken a very anti-patent position, very skeptical about SEPs, very skeptical about the issue of supposedly tickets, trolls, bad patents, not understanding the role that patents play in dispersion of value through the system. So what does that mean? In the sort of world described by Dr. Padilla, certainly it creates on the margin, I think, incentives to look at some countries like Germany, for example, where it's much easier to obtain a patent injunction than it is in the United States. China, incentives may be given for parties knowing that the courts, perhaps less of a rule of law than we have, are going to follow directions probably to uphold patents if parties are given incentives to come in. Also, legislation. Finally, the last bad thing to happen, a decade ago, the American Invents Act created a patent trial and appeals board which could entertain serial objections to patentability, even in the case when a patent had been upheld by a federal district court. This interfered with a key property right. The statute says a patent is a property right. That was being undermined and is still being undermined, although there's some debate about where the board is going. But that raises separation of powers questions, serious separation of powers questions. So I think it's been the perfect storm. And the three branches of the U.S. government have weakened the incentives for patenting here. And that also contributed to antitrust uncertainty, more talk about that. But that certainly may have some geopolitical implications beyond the scope of my comments. But I think I'll stop right now.
Christopher?
Well, thank you, Alex. And thank you to CIP Squared for inviting us. And particularly John Yoon actually was the person who extended the invitation to me personally. So anything I say that's distasteful, please blame him. He's the reason I'm here. But more importantly, I think Alden has done a wonderful job introducing the IP half of this discussion. I'm going to do a high-level discussion of the antitrust side. And I'm really struck by, what's of everyone's attention right now is the possible enactment of the American Innovation and Choice Online Act, otherwise known as ICOA, I've been tuning into television, watching ads on TV by interested parties, lobbying hard against it. And when you live in DC, you know that's when someone thinks something's got a chance to go, and because when they find it useful to buy here. But in addition, we have a similar move in Europe on something that is going to become law. It doesn't kick in for a couple years yet, called the Digital Markets Act. And in this, when I read them, they take a very different approach that fills me with the traditional admonition, those who forget history are doomed to repeat it. And what I find is that it's basically a move to making liability really key to market size. And actually, I wish it were market structure. It's actually just market size. And it reminds me of the long debate we've had over the years over structuralism in antitrust law. And it reminds me of the many, many attempts in Congress to change back to a structuralist presumption that's been rejected, and the many legislative proposals over the years that have been advanced unsuccessfully to return to the structuralist paradigm that reigned through, let's say, the 1960s. And I find that it's quite striking that people don't understand this. This is part of a larger project on my part. You'll see in Europe, they will say the DMA is no longer competition law. It's now ex-ante regulation. And in fact, what's frightening to me or striking to me is they invoke both financial services and more often telecommunications as example without any citations or reference to the century-long scholarly literature assessing how effective those things have been in financial services and telecommunications. And to me, this historical project is part of a much larger one to try to bring the wisdom from that to the debates as they exist today. So anyone who's taken antitrust law knows that we had once reigned by this notion of what we call the structure, conduct, performance paradigm, where we were unable to have the data to assess the performance of markets directly. And so we enforced antitrust law by a simple idea, which was certain market structures inevitably lead to certain conduct, which inevitably causes bad performance in the markets. Now, the interesting thing about that whole approach is even though it's called the structure, conduct, performance paradigm, we don't actually have to pay attention to conduct at all because it just falls out of the equation. It is just one thing that inevitably follows from the structure, so you don't have to analyze it. And in fact, that reigned pretty much supreme for an era, and certainly in the 1960s, very well embraced and very well established. And what you saw was a huge critique emerging that, in fact, certain market structures aren't necessarily the effects of anti-competitive activity. You saw the great literature being devoted to scale economies to understand that, in fact, there are natural monopolies, there are natural oligopolies, and that, in fact, that may be more efficient. You have the efficiencies defense proposed by Oliver Williamson. You have the maturation of natural monopoly theory and an understanding that at times breaking up those companies may actually not be in the best interests of consumers. And so what you then see is, what we forget, is a whole wave of proposals. So if you remember back in 1969, there was an organization called the White House Task Force on, let me get this right, on antitrust policy, most commonly known as the Neal Commission, published in 1969. And it proposed, or the report it did, proposed something called the Concentrated Industries Act that would break up persistent oligopolies. And it, in fact, was proposed in some form, and Congress never acted on it because this was right at the death of the structure, conduct, performance paradigm. My colleague, Herbert Hovenkamp, says it reads kind of quaint even on the day it was issued. It was originally done as a move by Lyndon Johnson, initiated in '67 to set up what he thought was going to be a re-election campaign that he subsequently abandoned. The White House turns over, Nixon charters there's a vigorous dissent by Robert Bork, a disavowal by Bill Baxter, and then we get the Stigler Commission shortly thereafter that sort of goes back the other way, and really have this proposal that did lead to concrete legislation that was not accepted. Then in the 70s, Phil Hart, first in 1972, began introducing the Industrial Reorganization Act in its many forms for several years consecutively, really trying to, again, break up persistent monopolies or penalize persistent monopolies without anything looking at it. And then sort of the most recent, Arita and Turner in their treatise had their no-fault monopoly proposal. which has been since disavowed by the subsequent authors, but they continue to leave in the book for historical purposes. And then you saw President Carter created the National Commission for the Review of Antitrust Law and Procedures, which led to another version of the Concentrated Industries Act. And none of them were really acted upon. They all proposed versions of what we called no-fault monopolization, but if you read in the literature, they often call them no-conduct monopolization, which is really what this was all about. And the reasons that we have to look back and think, why were these things never enacted? And the discourse is very clear, which is, sometimes the emergence of a dominant player is not the result of anti-competitive things that harm consumers. And some of it's just, luck. You see this, you look at the old formulation from Alcoa. I always have to teach my students when I talk about Forrest Gump being in the middle of the ocean and then everyone else gets wiped out and he gets the Bubba Gump ship monopoly supposedly because everyone, just by being luckier than everybody else, ignoring the fact with supply side substitution that this would never really happen and that just because one area is wiped out. But anyway, that's all the stuff we talk about to take a charming story and make it boring the way that law professors always do. But more importantly, what they found out is, and as I mentioned, sometimes they're natural features of the market, but most importantly, it's often the result of innovation. Process innovation where it makes a manufacturer more efficient. Efficiency is a very, very good cause of predation. Not predation, of success. And that, in fact, you see product innovation, which isn't going to lower prices. In fact, it often raises prices by creating something that's even better. And what they discovered that, in fact, the emergence of a persistent monopolist is ambiguous. And whenever antitrust law is confronted with a practice that is susceptible of both pro-competitive and anti-competitive inferences, we have to develop some doctrinal filter that separates the wheat from the chaff. And we do this repeatedly in all these other things. And historically, that has been the conduct requirement, which is the exclusionary conduct requirement that all antitrust people know so well. And yes, we're a little bit vague around the margins sometimes in formulating it, but we understand the functional role played by that doctrine that was understood at every single time this was debated in Congress and shows up in the debates and shows up in the legal literature surrounding it as a clear and established idea. And so what really is at stake is that if we're going to think about going back on that commitment, we have to go back and remember whether the reasons why we never went there. And that in remembering that, in fact, that the reasons for rejecting the no-conduct monopolization standards, do they still apply today? And the answer is absolutely they do. In fact, I think everyone in this room would be convinced, everyone in the US understands innovation is the hallmark of the US economy. And in fact, I love the quote that Angela Merkel, it's an old Prussian proverb, I heard her say it. They asked her once, what's the difference between Europe and the US? With all due respect for my friends in Europe. She said, in Europe, everything that is not permitted is forbidden. In the US, everything that's not forbidden is permitted. And we have this system which really fosters innovation and doesn't bar it ex ante up front where we don't know how. Backstopped by appropriate legal interventions should problems emerge, but we don't necessarily stop people from experimenting in those spaces to begin with. And that, in fact, it really does underscore our awareness of dynamic effects and how important they are to really understanding what is the source of real progress, because as we know, that growth, that innovation is the iterative process that's going to be constantly with us, that pushes out the production possibility frontier, that in the end is probably a stronger and longer term source and engine of growth and prosperity in ways that are reflected in the adherence to the conduct standard that people in the debate right now don't always recognize we would lose if we were to abandon it.
Thank you, Christopher. Jay?
Good afternoon. I want to thank the organizers for assembling this great panel. Looking forward to the discussion. So Alden and Christopher laid out framework for intellectual property and antitrust. I'm going to talk about some specifics. In particular, I'm going to talk about some recent proposals to regulate large tech firms. So recently, there have been several legislative proposals in Europe and US and elsewhere to regulate large tech firms. These include the Digital Markets Act in Europe, which is in the process of being implemented, will be implemented. And there's proposed legislation in the US, the American Innovation and Choice Online Act. So the DMA, Digital Markets Act, would impose regulations on gatekeepers and online platforms above certain size based on market capitalization and number of users. And these regulations include, they're very broad and sweeping, prohibitions against favoring own products, limitations on data use, access to platforms' proprietary data, and greater accommodation of businesses through potential modification of platform functionality, mandatory interoperability requirements, data portability, and additional notification for tech acquisitions. U.S. proposals have similar provisions, if not so sweeping and broad. So what's behind these proposals? In a recent speech, Assistant Attorney General Jonathan Cantor said that firms that dominate the digital economy have amassed corporate power that threatens our liberty. However, even as Cantor and others acknowledge, the digital economy has been a driver of growth and innovation. Nonetheless, the DMA invokes innovation as a rationale for these proposals. I would argue that, on the contrary, the DMA and similar proposals actually would do significant harm to innovation rather than foster innovation. So the argument why the proposals would spur innovation rests on the idea that leveling the playing field would allow firms to, smaller firms would have a fighting chance against these large tech behemoths, and which would make investment in innovation more rational. However, this notion lacks any empirical support, and moreover, it doesn't make much sense as an argument. It's a matter of theory. Leveling the playing field by taking away gatekeepers or large firms' rights to exploit fully their advantages as a result of innovation over competitors would weaken the incentives to innovate. What you need for incentives to innovate is the ability to exploit your advantages over rivals when those advantages come from successful innovation. Otherwise, others can just free ride, avoid investing in innovation, and just wait for others to innovate. Just take advantage of others' investment. Why would you invest on your own? So negating the advantages of, so the ability to exploit advantages over rivals that come from successful innovation is a necessary element of innovation. And negating those advantages weakens incentives to innovate. The idea of ex post leveling the playing field is actually alien to innovation. So one way that innovators can achieve advantages over rivals is through IP rights, like patents, that allow patent owners to exclude others from using the IP owner's innovation. Patents may exclude competitors from using the innovation unless the competitors license the patent from the patent owner. And this is, after all, an IP conference, so acknowledge the importance of IP rights. But as we know, patents do not offer strong protections for many digital innovations. Patents don't generally prevent competitors from offering similar digital applications as those offered by the innovators. Nonetheless, as most people acknowledge, the digital economy has not lacked innovation. So what gives these firms in the digital economy the incentives to innovate despite the relative weakness of IP rights in excluding others from, copying their innovation? Uber has developed a platform for rideshare, but Lyft has one as well, and others. What is it that gives them that incentive to invest in innovation despite, I would say, relatively weak IP rights? Well, it's the things that enable others to receive a return on investment in innovation. It's first mover advantage, it's indirect effect, it's scale economies, trade secrets, investments in relationships, drawing in customers on both sides of a platform, realizing the value of innovation by selling your startup to a larger firm that could better exploit the innovation, or the ability to build a moat around your product to exploit the advantages over competitors. But those are the very things that the DMA and other similar proposals seek to eliminate. So these proposals go to the very lifeblood of digital innovation and would, as a result, produce a lot of harm. So I think I will stop here, and hopefully we'll talk more about the DMA.
Thanks, Jay. Aurelien?
Right. Thank you very much, Alex. And thank you, George Mason University, for having me. It's a great pleasure to be here and discuss antitrust and innovation. I want to step back a little bit and have a broader reflection about where are we and what are the trends in those issues. We live definitely in extraordinary times. And I think it is very unparalleled. The name of the conference, IP on the wane, tells a lot. Question is, why do we have a weakening of IP? And also, why do we have this tremendous increase or antitrust populism? And I think the two goes together. So why do we have IP on the wane? One explanation is, well, there may be a preference for the large tech, and the weakening of IP in itself organizationally favor large firms. And I think Jonathan, in his latest book, explained that and demonstrated it very convincingly, that the weakening of IP contributes to favor large firms. But at the same time, it doesn't explain why perhaps the same policymakers or others who are in agreement with them engage in this populist antitrust, which is about against a large company, and sometimes exactly the same companies. So there's this sort of paradox in here where you have one area of law, IP, that goes very much in favor of larger, perhaps tech companies, and another area of law, antitrust, that goes against those very same company. So I just wanted to reflect on that and research a little bit. And this is part of a report that ATI is going to release very soon. It's a reflection of this interaction between antitrust and IP and how to better improve this interaction so that we have an optimal innovation policy. I mean, this paradox of having the same policymakers engaging in antitrust populism, which is going after the large company just because they're bad, just because they're large, and these IP reformers that go against some IPs that may benefit exactly the same companies that they go against in a different department. I think the common denominator and the main explanation is an assault on innovation. An assault on innovation, the disagreement with the effect of innovation, and more specifically, with the way innovation is commercialized. So I'm just going to try to explain to you and try to convince in that way. Innovation takes place in two ways. There's first a difference between invention and innovation. Innovation is the commercialization of inventions. And these commercializations takes place in two ways. Either within the firm, through a corporate scale, therefore you need the scale of the company in order to commercialize the innovation, or the innovation takes place through the market, through the licensing. You have a great idea, you patent it, and then you license. So the difference is that the innovation can take place either within the firm through vertical integrations or on the basis of the market-based exchanges. And what is interesting is that today the current trends go against the two sides of the same coin, which is the coin of innovation. It's like attacking the corporate scale and at the same time attacking the IP right, which enable a lot of companies to license and propose their ideas on the market. So I think that is very, that explains a lot in terms of favoring, I just try to undermine the commercialization of innovation. That explains the idea that the policymakers are still favoring the idea of perfect competition. That their idea is to have competition in innovation with on-the-spot transactions where restraints and investments and long-term relationships are not possible. One way is vertical integrations. They don't like these restraints that vertical integrations bring about. And also, they don't like the IP, the restriction of competition that are inherent if we want to have an optimal innovation policy. And these attack on those two sides of restraints and the very contractual bases that are prerequisite for innovation shows that this model of perfect competition, where we think that we can maximize competition with no long-term investment, is still very detrimental, and we need to go away from that perspective, and we need to embrace a more realistic approach to competition, which is dynamic competition, which relies on restraints, on contractual agreements that can take place over time. And why innovation matters in general? Well, innovation matters because innovations are commons. There's some explanations like the positive externalities that are created by innovation is tremendous. Most of the time, innovations benefit the general society rather than the innovator itself. And that is extremely important to have in mind. And if we don't encourage that innovation, we'll have this sort of tragedy of the commons, but reverse, if you want. So what's the path forward? Well, the path forward is to have some sort of IP reform where we clearly have a different approach on the way we regulate IP. We should really embrace IP as a way to exclude and the exclusionary aspect of IP. And the new Madison approach on ACP has been rescinded, and I think we need a new approach. We need a new approach which explains that there's a fundamental aspect on IP where you need to be able to exclude some trespassers because that's exactly the way you can market your innovations. And on the other side, on the side of the scale, on the side of the antitrust, I think we need more antitrust humility in light of a constitutionally protected right, which are IP rights, right? I mean, we also have to have a more historical perspective where IP are constitutionally protected right, whereas the Schuman Act just came almost a century later. So I think the better interactions between antitrust and IP is to understand that both protect and should embrace the sort of innovation that they are supposed to protect, this corporate scale and the property aspect level of IP. And there should be a sort of supremacy or preeminence of IP when it comes to antitrust, and antitrust should have greater humility when it comes to patent disputes, where contract law, I think, are better suited to resolve those patent disputes.
Thank you, Aurelien. So just like the previous panel, I'll pose some questions first, and then I'll open it up to Q&A from the audience. A number of panelists, Christopher, Jay, and Alden, have talked about the ICOA, America Invention and
American Innovation and Choice Online Act.
Okay, got it. And that's proposed legislation in the U.S., and then in the EU, there is the Digital Markets Act, which is in the process of being implemented. So Jay in particular listed some of the specific provisions of the DMA that are, I think, paralleled in ICOA. Both Jay and Christopher pointed out that these regulatory type restrictions are based on size, not even on structure, and there are problems with inferring competitive intensity from structure as well. But I want to, I won't say play devil's advocate, let me say Lena Khan's advocate, and ask a couple of things. On the one hand, the various specific types of activity that are called out in these two pieces of legislation, such as self-preferencing, limits on data use, mandatory, well, there isn't mandatory interoperability, I don't think, in ICOA, but each of these types of behaviors still have to pass muster in some sense, not necessarily a showing of a lessening, substantial lessening of competition, but I think the wording is a material risk of harm. So one question I have is, what's wrong with that? It's maybe I'm an economist, not a lawyer, so I don't understand what the meaning is of all these slight nuances in wording, but if there's a material risk of harm, shouldn't that be something that is a standard for a finding of whether something should be struck down? And secondly, yes, the application of these acts or potential acts is limited to large firms. Maybe that's a plus, because if the rules are bad, at least it's cabined to large companies. So let me, I don't know who wants to take this
So
on.
just to speak on one thing, ICOA actually does have an interoperability mandate. So there is a provision that restricts, that would penalize restricting interoperability in a manner that would materially harm competition. And so, I guess the quick and dirty answer to a lot of these is that things like tying, which is one of the restrictions in ICOA, things like self-preferencing, non-discrimination mandates, exclusive dealing, economists have now all long understood are ambiguous practices. And yet we have here, if you hit a certain threshold and without, that they don't really examine in ways that we would normally expect them to do, critically, how this would work. And so my favorite moment, Herb Hovenkamp, my colleague, got really mad at something Elizabeth Warren did, which is she's mad about Amazon self-preferencing its own private label goods. Before I went to business school, I went to law school, I went to business school. I worked for Procter & Gamble, and private label goods were the bane of our existence because they would underprice us with very high quality products, and this is a really good thing for consumers. And so he loved to show the battery. That was her example, Amazon batteries. The price cost margin in branded batteries is so high that a categorical ban on self-preferencing in that product market would be so bad for consumers, it's just staggering. And this is the thing that it just invites you to do, is to look at these big, broad brush things. And this is why good old-fashioned case-by-case antitrust did us so well. And this is why this sort of broad brush stuff doesn't work very well. The one thing about interoperability, it was interesting. I love Jay's comments about investments trying to get ahead. That's why you do it. That's Trinco. Europeans hate Trinco, but that is Trinco. But buried in Trinco is another thing that we forget, that there's a non-economic part of vertical integration. There's a technological part. I mean, we've fallen in love with coasts and all these other things, but we forgot about good old-fashioned thermal efficiencies, where when you're refining ingot into pipe, putting them together while they're still hot means you don't have to spend that much energy to heat it back up again. And what you'll see is in Trinco's language, there are technical aspects of this about interoperability. Forcing things to interoperate at certain points requires engineering considerations which don't work. And for those of us who lived through unbundling under the 96 Act, we can see it works sometimes. Number portability works, but the stuff deep in the guts of it, no. And so understand, just because they had natural monopoly characteristics and all the economists say, hey, let's take that element out, it's not that simple. And so understanding how actual systems work on a technical level in addition to an economic level is not well taken into account by any of this legislation. It's the aspirational thing that you see that led to the 96 Act and its ultimate failure. Yep.
So,
Go ahead.
can I just say something about the size issue? So the size sort of requirement, the size thresholds in both the ACOA and the DMA, I see them as big problems, especially for incentives for innovation. Basically, these provisions punish companies for success and growth. If you grow, if you succeed, if you innovate, and that innovation blossoms, you are subjected to draconian regulations in case of the DMA. And that's sort of a huge disincentive. As far as whether you are cabining the effects by only focusing on large firms, I think if self-preferencing is beneficial for smaller firms and efficiency enhancing, I think that it's also efficient for larger firms. And in fact, because there are larger firms and affect so much more of commerce, the effect of reducing this potentially efficiency enhancing, output enhancing behavior is, the costs are really high. And if we think about it, self-prefacing is everywhere. It's ubiquitous. If you have a small firm with tech support, you shouldn't have to go out and solicit tech support from a third party because you have local tech support that you work with. And this is true for larger firms as well. Using affiliated services saves costs. There is vertical integration has significant benefits. There is reduction of double markup, but there's also enhancement in investment and more integration that produces synergies. By prohibiting or discouraging self-preferencing, you are eliminating these benefits. And I should mention, one last thing about self-preferencing. There is a significant cost to prohibiting self-preferencing or making it regulatory expensive to defend self-preferencing. A company like Netflix may just forego producing its own content, just only include third-party content. So it's actually output reducing on its face. All right, I'll stop there.
Perhaps one word on the size effect. We don't have to think that these regulations are only for 4 or 5 companies, because that's not the case. For example, in the DMA, there's this notion of foreseeable gatekeepers. You can be subject to the DMA if you're a foreseeable gatekeeper. So what does it mean? We don't know. And so it's not about, first, the DMA is not about 4 or 5 companies. It's about 15, perhaps. But if you expand and say, okay, let's talk about foreseeable gatekeepers, it's not 15, it's like 30, 40, 50 companies. And so that's way bigger, right? So I think it's Article 12 of this DMA, which said this notion that, okay, all these obligations and prohibitions apply to the gatekeepers, but they could potentially apply to non-designated companies. And so you don't have also this designation process, and you have this huge legal uncertainty. Second aspect is the regulatory expansion. When you're not subject to these regulations, you think of not expanding because you're going to be subject to these regulations. So it's a barrier to expansion which is tremendous. And finally, perhaps, without even talking to the substance of these regulations, the potential for further entrenchments. Because at the end of the day, this is what we apply like a kind of common carrier antitrust, where there's a duty to help rivals. At the end of the day, wouldn't these companies be regulated like public utilities, which at the end of the day, gonna entrench them? There will be less innovation, more harm to consumers, but they will still be there. They will be less subject to disruptions. And that is an effect for all the companies and, of course, consumers.
Okay, yeah, good point. I had forgotten about that foreseeable part. That's a loophole you can drive a truck through. We're going to turn shortly to Q&A from the audience, so gather your thoughts. But I want to ask Alden a question. Alden, you mentioned with respect to injunctions by SEP holders that those rights were weakened by the Supreme Court in 2006. I think that's the eBay decision?
Correct.
Okay. But you also said that it's easier to get an injunction in Germany. And I was wondering, with respect to the global issues that were talked about in the previous one, is it possible that getting an injunction in Germany, I mean, Germany is a fairly large economy. Could it be that getting an injunction in Germany maybe has broader effects?
Well, I mentioned Germany, but I think the main point, one might also say that for China. It's my understanding, certainly, that if there are some areas that are no longer easily patentable, like medical diagnostics in the United States, if you go to China, you can patent those, and you're almost certain to be able to defend that, including through injunctive authority, if the Chinese want that investment. So, I mean, I think the bigger point was that by artificially limiting the property right, this is a classic property right, basic property law is the right to exclude. By artificially limiting the right to exclude for standard essential patents, which are keys to these big standards, and we heard from Jorge Padilla about that in effect lessens the ability of the United States, certainly in geopolitical sense, to be able to promote its standards, because there'll be a disincentive to invest in standardization, patents that could be included to improve a U.S. standard. So I'm not exactly answering your questions, but I mean, I think the long-term implications or the indirect implications of limitations on injunction are direct disincentives to improve, to invest in areas where you can't get injunction. Maybe you can get some injunctions outside the outside of the standards, but if you want standardized technology, which is critical to the dispersion and distribution of technologies throughout the economy, you don't want this sort of disincentive.
Very good. Okay. You were there first. Could you please give your name and affiliation?
Sure.
And your question?
My name is Gary Lauder, Managing Director of Lauder Partners, my own little venture fund, and I'm a speaker tomorrow. Firstly, in answer to the question that you asked earlier, it is the case that multinationals who are going against other multinationals sometimes choose China or Germany as their venue more often than the United States because of the ability to get injunctions, and China is also effective because often the product in question might be manufactured there, which says a lot about our system. But the question I was going to ask is, it is the case that many major high-tech companies that are sued for patent infringement use their huge balance sheets to have many countersuits on proceedings against the plaintiffs, particularly in the PTAB and in other countries and so forth. What would it take for that type of behavior to be reined in on antitrust grounds?
It's tough. So it's Pennington immunity. There's a good faith standard about that that's going to be there. I mean, there's fraud in the market, fraud on the patent office. There's certain limits we have. But one of the things that always bothered me about like FTC conditions not to seek injunctions, you have rights. You may lose, but people ask, how do I keep from getting the suit? The answer is someone can bring a bad suit, and hopefully you have the tools to dismiss them early. But unless there's the standard of bad faith below Rule 11 or whatever, I mean, it's a really hard thing because, among other things, we're saying you have a First Amendment, not just an economic policy right, you have a First Amendment right to petition.
Let me just add a word on PTAB. I think PTAB was particularly troublesome because one of the justifications was, oh, district court proceedings last too long. Let's have these simple proceedings. Well, take care of these, have these administrative proceedings. Well, no. You've had serial proceedings based on different claims within the patent, and these people are not officers of the United States. They're not truly accountable. They haven't been Senate confirmed, unlike federal judges. And basically, you're stripping federal courts of the ability to oversee a property right, which by statute, the United States Code says a patent once issued is a property right. And the idea that a bureaucrat can, in effect, strip a property right, which a Senate-confirmed judge or in a judge jury trial say, hey, you found that property right to exist is ludicrous, I think, and really, I think, underscores the problem with this whole PTAB system, which in my view should be scrapped.
Jonathan?
Sure. So this is more in the way of a comment than a question, but I'd be interested in your thoughts. To what extent can we trace the current antitrust populist thinking as reflected in the proposed statutes and various actions by the agencies, in particular the FTC, to the treatment by the agencies in some courts of SEPs? Because essentially what happened in the SEP area is that a loose contractual provision, the Fran principle, was converted into an antitrust doctrine. And then essentially the way that thinking worked is it took that large population of patents and created, that's going to be a special antitrust category, which is not reconcilable with the general rule that IP rights, as the guidelines state, are not to be treated any differently than any other property right. And then once you're in that category, you can't get an injunction, and you're treated, in FTC v. Qualcomm, you're treated as an essential facility. So it seems like the intellectual origins of this much bigger thing that's happening today, we could trace it all the way back to the treatment of SEPs under the antitrust laws, both in the US and in Europe.
Yeah, perhaps I can just say one word. I think that's an excellent question and excellent inquiry. Perhaps the answer that when I think about it, is the non-discrimination principle. We apply FRANT, non-discrimination principle, everywhere. And it started with net neutrality, then we had search neutrality, then we have platform neutrality. The idea is to have neutrality everywhere and non-discrimination principles everywhere as well. FRANT, but in the DMA, it's non-discrimination without saying, it's basically FRANT imposed obligations without saying. So I think the idea of neutrality and prohibition of self-preferencing, of course, the idea of neutrality, therefore a non-discrimination principles, and therefore a price regulation, indirectly, I think it's just common to the SEP antitrust populism.
Yeah, the FRAN principle is in the DMA, so what's happened is that the FRAN concept has now been generalized beyond SEPs to a huge portion of the economy. Yeah.
Exactly.
Jorge?
Yeah, so a couple of comments on the DMA. I think that the first thing to note is that the quantitative thresholds that refer to size create a rebuttable presumption. They don't lead necessarily to designation, and it's going to be fought. I mean, a number of people that are above those thresholds will argue that they are not really gatekeepers. And what is a gatekeeper? A gatekeeper ultimately is somebody that is must-have. It's somebody that you need to deal with if you want to be in business. So the Commission is never going to use the words essential facility, but that's what they are. And if you want to rebut the rebuttable presumption, you need to argue, you need to demonstrate that you're not must-have. And I think that that's going to be important, and if the Commission doesn't agree with those things, I think that it's going to have to defend its positions in court, because it would be litigated. So I think it's not that, necessarily, resolve or I don't think that I think that there is ground for discussion there. The second issue that I would like to mention is that, if you look at the history of European antitrust, and if you ask yourself the question, did Microsoft stop innovating because of the media player decision? I don't think so. Did Google stop innovating Google Shopping in Google because of Google Shopping? I don't think so. And the same applies to Android, and I could go on and on. Is it the case that because you are preventing from self-preferencing your shopping vertical, that you're not going to stop? You're going to stop innovating in your main in the search engine? I don't think so. And I think that then there is, and this, and I think that that's important because the arguments about innovation have to be credible on the basis of evidence. And in particular, when the same American companies that come to Europe to argue that if they are intervene, if there is intervention, they're going to stop innovating, are the companies that come to complain about others and tell them, the European authorities, actually, don't worry about innovation because, you should intervene and there is not going to be an impact. I think that there is a problem of credibility. And then there is another point that I would like to make, and this is a question, which is, if we think about IP law, we give people patent rights, exclusion rights, and we give them for a limited period of time. How long do you need to hold a monopoly in a relevant antitrust market to recoup your investment? Do you need to be a monopoly for more than 20 years? Because some of those guys have had monopoly positions for a bit longer than that. So it may be that there is a point in which you think the ex-ante incentives are there, and now we can try to regulate and impose access conditions. Of course, under proper terms, fair, reasonable, and non-discriminatory, which in this context I think that is less complicated than SEPs, because we need to go back to the many, many years in which we have been doing access pricing in other industries. Sorry, I went a little bit too long, and maybe I was the devil's advocate, but I think that I wanted to be controversial.
Yes, well, let me be the angel's advocate now. I question the premise that a patent confers a monopoly in the first place. And at least in the past, the competition agencies in the US explicitly said that that's not the case. What was the second point I was going to make?
But the monopoly that I was referring to is not patent holder. In fact, I think that we give them 20 years, even if they may not be monopolies. So I was thinking about the company that holds a monopoly in a market, de facto. How long does it need? How long can it justify that monopoly on the basis of the need to recoup investment?
But these are the proposals I was talking about. Persistent monopoly is evidence of market failure. And that's something we've consistently rejected because it could be a company that continues to be innovative. And so without a filter to separate the two, the fact there's no magic number. It's like 20 years they must be a problem. That's not possible. That's not necessarily follows. And the other, I understand what you're saying about rebuttability. The problem is all this stuff is so vague. We have so few standards, and the law is really, everyone says ex-ante guidance and clarity, and everyone who looks at it says, what clarity? We're really going to be years. It's like old-fashioned common law adjudication to get through this. But the other thing is, when you say Microsoft is still innovating, you and I both know there's a little bit of problem here, which is we don't really care. That's not a real proof. The question is the marginal impact. We're all economists, we're all marginalists, right? And so the question is, yes, the fact that Microsoft is still innovating doesn't answer the question whether they're doing it on the margin in the most efficient way. And so that's a harder question to answer. But ultimately, what I take for you saying is we're too ambitious about remedies. In the sense that the remedy that we created for Microsoft didn't really matter. And the thing that worries me is the DMA has a laundry list of mandatory remedies which will apply to every case, whether it's self-preferencing or discrimination or whatever. And normally we tailor remedies, and I hope that they'll interpret the DMA to allow that, but on its face, they all apply, which is contradictory. It's not the way that Europe usually do it. You have have a violation, you have to have at least one remedy, and you pick it as a judge. That's not the way the DMA reads. And that leaves a lot of room for interpretation.
I think that there is going to be a lot, if I may, there is going to be a lot of discussion about
Clearly.
how the obligations under Article 6 are implemented.
Yeah.
And I think that there is going to be lots of fine-tuning of remedies.
A lot of employment for lawyers and economists.
Okay, I think we have time for one more question comment.
Thank you. So I have a very general question, actually two questions.
First, your name and affiliation.
Okay. I'm Lila Kish. I'm a Hungarian visiting scholar at GAI here in George Mason University. My question is regarding European regulation or over-regulation from a US point of view. The question is whether this kind of over-regulation regarding the digital markets and the digital law is influencing, how it influences the USA and how the USA could defend this influence in order to protect its market interest. And the second question is whether the USA should take the leading role in digital legislation and regulation in order to protect its economic interests.
Well, just a comment, it's personal opinion, but my sense is that right now, in fact, the executive branch is very supportive of the European regulation. In fact, the recent Fordham speech, I've heard the heads of the FTC and the Justice Department Antitrust Division almost laud Europe for taking the lead in the DMA, the kind of policy that I think those officials would like to implement if they were able to. So that we'll have to see what happens in the future.
So, go ahead.
Sorry, I just wanted to say it will have a tremendous impact, and that's why also the European Commission just opened an office in San Francisco Bay Area. It's even beyond the Brussels effect. It's Brussels in the Bay Area. I think it's the DMA going to be the de facto rule of digital market in the sense that it's perhaps unlikely that those antitrust bills will pass, I don't know. But if they don't pass, then precisely it will set standards. And yeah, I think it's going to be regulated. Those American tech companies will have to go to the European Commission, which would be just around the corner in San Francisco, just to understand how they implement, when they have an innovation, when they have disruptions, should they refrain, should have a precautionary approach, refrain and get compliance first, or should just innovate? And I think it's going to be a regulatory dialogue that also have dark sides, which is, I think, regulatory capture. But yeah, I'm very concerned about these aspects of the DMA being just the world standard.
So very quickly, I'll add, multinational companies, large tech companies do not operate in a fragmented world. What happens in Europe affects US and vice versa. If there is a significant tax on innovation, which is what the DMA is, it's going to affect innovation of US companies that will affect what happens in the US. It's not like the impact of that could be cabined in just Europe. So it will have a significant effect on the world economy.
Wow.
Yeah.
Except GDPR doesn't affect small firms. And that's been a disaster for SMEs in Europe, as well as here. I mean, and we're having the same thing with CCPA, so it's the same issues.
Okay, well, we're several minutes over. I want to add my thanks to the panelists' thanks of our institutional sponsor, which I understand is called SIP Squared for short. And please join me in applauding our panel.